world are upon us today. The petitioners are not here to indict or vindicate law enforcement, and they are not here to indict or vindicate Mr. Brown. They are here in the interest of advocating for transparency in the hopes of aiding the national conversation we find ourselves in about citizens' interaction with the police. Your Honor, if I may, I'd like to give you a little bit of procedural background because I believe there's been some consternation about that, talk about the factual background, and then talk about our arguments in favor of release. Is that all right, Your Honor?
Yes, sir.
Your Honor, the petitioners, the original petition, and I will say there have been three, and I can delineate, was on behalf of a smaller subset of petitioners that are before you today. We attempted to file that petition last Friday. The courier service that we used to bring it to Pasquotank County was met with the unexpected closure of the clerk's office, and it could not be filed at that time. I personally attempted to locate Chief Resident Superior Court Judge Tillett to see if he would accept the filing. He and I had a conversation on Saturday evening where he indicated that he would prefer we file it on Monday morning. It was here in Elizabeth City, and that's what we intended to do. It occurred to us, based on, as Your Honor is aware, this is a quite evolving matter, that there were also static cameras mounted on poles here in Elizabeth City. And so our original petition went to the sheriffs in Pasquotank, Perquimans, and Dare County, and the North Carolina SBI. With our amended petition, the first one was filed at 10:45 a.m. on Monday. Our amended petition was filed at 10:47 a.m. on Monday, added Elizabeth City Police Department, and we served all of those petitions. Actually, we served the one we tried to file on Friday via email and fax the best we could. And then we served the other one on Monday, right after it was filed. Later that evening, we got an order signed by Judge Tillett referencing the respondents to the amended petition, which included Elizabeth City, ordering them to produce the recordings for in-camera review. It did not set a person or place or time, but it did have that order. And it also set the notice of hearing for this time that we're here this morning. And it ordered law enforcement to notify law enforcement whose image or voice appeared in the recordings to notify them of this hearing and their right to be here today. I believe this is the 33rd or 34th one of these I've done, and we always seem to get a little hiccup in that step, in that I don't have control over what service is done on law enforcement because I don't know who's in the video, and so that's where it becomes a problem. I think there has been a lot of unfamiliarity with the law, and part of what my mantra has been always is we've known from the very start that it would take an order of a Superior Court judge to obtain release, and we've not wavered from that. We get this process. In any event, Your Honor,
did you find, was the request for the poll camera that was produced for you, was that produced to you as well by the Chief of Police?
I'm not sure that I'm following, Your Honor.
There was a video that was released outside of the appropriate procedures that was reported to have been provided to a media outlet that was on the internet yesterday. Was that released pursuant to a petition you filed?
Your Honor, I don't know why it was released. Here's my understanding. It was unclear to me. I looked at the coverage of the first petitioner, the Daily Advance from last year, and it indicated that the Elizabeth City security cameras were put up at the request of police and were operated on behalf of the police. That's the last information I have about those cameras. It is my understanding, and so they fall into one of two categories. If they are operated on behalf of the police or by the police or law enforcement, then I believe they are under the statute. Alternatively, if they're operated by the park department or some other department, they would be public records under the law. My advice in any of those situations, if you don't know, are these operated by the police or not, because people aren't saying, and the police are not obligated to answer questions like that, make your public records requests, but we're going to make the petition in case they are law enforcement recordings. It's my understanding that they were released pursuant to public records requests. So in standing in front of you, I don't know Elizabeth City's position on whether these are law enforcement recordings or not. based on my information from the Daily Advance from a little over a year ago, I thought they were. To answer your question specifically, I did not receive a copy. I saw them on the internet as well. I saw a video on the internet, and I believe I've only seen one.
I think there was one. Thank you.
In response to service of the amended petition, Mr. High contacted me on behalf of the Perquimans County Sheriff and indicated, he made an appearance and indicated that they do not have body cameras, and so there was nothing to be had. And I certainly told Mr. High that I understood and I would be happy to represent that to the court. And Mr. High appeared here this morning out of an abundance of caution. Similarly, counsel for Dare County contacted me and indicated, I talked with Ripley Rand first, and then his partner contacted me in writing and gave a letter, which I believe the court has, that they also don't have any responsive recordings to this incident, and we understand that. Ms. Martin and I have been doing public records cases for decades, and we're used to asking for stuff, not knowing whether it exists. This is kind of like that process to us. Our process has always been ask for the widest swath, and that way you'll get what you get. There was one of these proceedings in Mecklenburg County. The request was made for a particular type of a particular incident, the recording of that incident, and unfortunately the Mecklenburg Police Department decided to take the most narrow view possible of that request and produced, my recollection is 2 minutes and 30 or 40 seconds of video, and it ended abruptly at the shooting of the person in a Burger King parking lot. Much to everyone's surprise, including Judge Bell, who was hearing the hearing, there was about another 11 or 12 minutes of video that had not been disclosed to the judge and had not been, certainly not disclosed in the process. That came about because it was shown to the city council in Mecklenburg County. Taking that information, that's why we make our requests as broad as we do. We're not trying to give anybody any hassle. We understand what the process is. We understand that it takes up the court's time. This is the process that our legislature has given us, and so we use it. We fully acknowledge Your Honor has an immense amount of discretion in what to do here, and we're always cognizant of that. In this particular incident, Mr. Brown, law enforcement went to Mr. Brown's house to serve what I understand are both arrest and search warrants. There was an incident, a shooting happened. Mr. Brown died soon thereafter, and it's my understanding that both Pasquotank and Dare County deputies were at the time of that incident, and then Perquimans deputies came in after the fact to both help with crime scene security and then both spontaneous gatherings at the location, and then it's my understanding at City Hall and the Sheriff's office parking lot. That's the gamut of what we're looking for. As I said at the beginning, we're not here to indict or vindicate anyone. We're trying to understand what happened. To suggest, as Mr. Williams has and perhaps Mr. Womble have, that there's not a compelling public interest in this proceeding, the number of petitioners we have, the fact that you and I are probably appearing on television screens and computer screens all over the country at this point in time, and all that we've been through in the last year is absolutely evident that there's a compelling public interest to release these videos. I have attached the 7 officer-involved shooting orders from other courts, and you will see in our index, it's a fairly short window most of the time when those recordings are released. Some of them within less than 2 weeks, some of them within about 2 weeks of the incident. Certainly, the ones that are at the beginning, it was unclear prior to having this statute whether recordings such as this were public records or personnel records or records of criminal investigation. The legislature has set us at least somewhat straight in that regard. They're not public records, but this is the process that everyone is given to seek their release. And that's the court with the opportunity to review them and apply the factors that the court thinks is appropriate. As we've stated in the brief, and I'm assuming Your Honor has reviewed the brief.
I have your brief and the attachments, and I have reviewed.
Okay, thank you. The radio traffic indicated that Mr. Brown had been shot in the back, which also adds interest in this under the circumstances. Mr. Womble's recitation of what happened, which stands in stark contrast with the family's attorney's representation of what happened, to me is is absolutely compelling to release it. Everyone can have their opinion of what happened. The video may or may not show what happened or how it happened. And so releasing that will provide the information. The best vaccine to rumor is fact, and it shows the facts of what they are, or it may not. I have been, as I've said, I've done a number of these, and I've been in circumstances where somebody in an incident like this is claiming excessive force or something like that, police saying it didn't happen. And both results have happened. The video gets released and it supports the claims of excessive force, or it absolutely refutes the claims of excessive force. I have also had situations where it doesn't tell. It leaves it to be concluded. All of those things are important. As we state in our brief, that accountability is important, but in order to hold public officials accountable, one has to see what's going on, and this is very evident of that. I'm sure Your Honor is aware that in Minneapolis, in the George Floyd situation, that the original police report indicated that Mr. Floyd had a medical incident and that caused his death. If it weren't for the folks standing beside, I don't know if we would have ever known what happened in that case, and certainly Your Honor is aware of how that played out in the last month, well, even last week. That's the type of stuff that we as citizens, in trying to hold our public officials accountable, it's information. I have seen videos of officer-involved shootings. I remember one from Moore County. It was a hailstorm of bullets. It was very disturbing to watch. And I remember that it struck me again how difficult law enforcement's job is when a young deputy turned around and he was absolutely terrified of what had just happened. And it was important for me to see that and the public to see that so they understand how difficult this job is. It's also important for law enforcement to see how their interactions with the public have an effect on people. It is part of that conversation. Your Honor, we do not believe that the release of these recordings will jeopardize an ongoing investigation or the pendency of any charges. There are none pending. Apparently, there are active investigations. You will see in the orders that we've attached that these videos just like this have been released as investigations are ongoing. It's my understanding, and I know representatives of the SBI are here, that the director of the SBI has indicated that he's taking no position but certainly doesn't object to the release. If they're the investigating agency, I think that adds a lot of weight. And I hear Mr. Womble that you can use certain types of evidence to test the credibility of people. I've been around the block, you've been around the block. To believe that people involved in this situation aren't talking and haven't talked to one another and aren't comparing notes of what they think happened, it is just not accurate. It's what happens in these situations. It happened, I'm sure it happened immediately, as it's happened immediately in every one of these videos I've seen released. What happened, it literally starts right at the moment of the shooting and continues on. That's not going to change the facts. This was done in the open. Nobody had any expectation of privacy, be it the officers or Mr. Brown. And then, in addition to that, Mr. Womble has argued, and Mr. Williams has argued, that the names of the faces of the officers involved should be redacted. Certainly, that's within your purview, Your Honor. I know my clients have been asking for the information that is absolutely public record under 153A-98 with respect to the officers of the Pasquotank County Sheriff's Department. And so far, that information has not been produced. And as Your Honor is aware in our brief, we list that information. The names of these officers are going to come out because they have to give that public information. I don't want to be back here in a public records fight. There is no legal justification to withhold the information that the General Assembly has made public. If that information is out, then there's no reason to blur the faces of the officers. I am deeply disappointed, and I completely understand of threats being made, but the release hasn't been made, and there are already threats. I don't know how releasing it is going to change whatever somebody's motivation is to make additional threats or that sort of thing. And Mr. Womble, I believe it was, or maybe, no, as Mr. Williams indicated, that somebody who didn't do anything wrong might be might be thrown into that pile of people that did. Well, releasing the video and seeing who did or didn't do what will work to alleviate that. Keeping it secret keeps the group of people unknown, and thus people are going to do what people are going to do. You experienced and you talked to us in chambers about the security. I'm looking around and there's security all around me. There was security. I couldn't even get parked near the courthouse. And if that's what needs to happen, that's what needs to happen. I know that you have a security detail. I know that others do. And if that's what needs to happen, that's what needs to happen. With respect to the pretrial publicity, the court is well aware, and I'm sure you have access to the School of Government's bench book on pretrial publicity, and there's a whole host of things that a presiding judge can apply to deal with pretrial publicity other than sealing a particular record. I can't speak to the wisdom of what they did, but through this process, the General Assembly has made these recordings, which are now in possession of the court for in-camera review judicial records. And there's a well-established First Amendment right for access to judicial records. And any order sealing those records must be reviewed under strict scrutiny. And we don't think that such an order could withstand strict scrutiny.
But I'm not being asked to seal records. I'm being asked under the statute whether to disclose records.
I get that nuance, Your Honor. What I'm getting at
That's not
is,
a nuance. That's a pretty bright line exception or difference.
I understand that. What I'm getting at is the General Assembly has seen fit to put these records and make them judicial records. And thus there are First Amendment concerns that then attach to those records because they now are judicial records. And so by not releasing them, we think that's tantamount to a sealing order or perpetuating their being sealed. I don't mean to be pejorative in using the word nuance. I just think we have a difference of opinion, and I respect your understanding. The other aspect is the notion of delay. And if there's a First Amendment right to these recordings, that every day that they are not released harms that right, and it's irreparable. And so release, that weighs in favor of release. It appears, if I understand correctly, that the sheriff is in favor of release. The SBI doesn't take a position and doesn't object to it. The Brown family is in favor of release, and it's the district attorney and Mr. Williams and his unknown clients who are objecting to release. Our partner Hugh Stevens just finished an amicus briefing in a Supreme Court case here in North Carolina, and the name of it is not coming to me, but it involved an anonymous case filed in Cumberland County. Dovido. So there you go. Where we and others challenged the fact of proceeding anonymously. I don't think you can do that under North Carolina law. If Mr. Williams is making an appearance, he needs to identify his client for the court. Certainly I understand the practical reasons why he's not doing that, but I don't think he can do that under the Dovido case and comport with North Carolina law. If he identifies his clients, again, all of the reasons to blur and withhold the public records regarding the officers of the Pasquotank County Sheriff's Office fall away. And so I think that's important. There are no charges. Lastly, it is my understanding, and it's happened in the vast majority of these cases that I've done, is the recordings capture transmissions of law enforcement broadcast over the public airwaves. Under the public records law, that is unequivocally a public record, and it would take law enforcement coming to make a motion to have those not released, and they have to bear the burden of that. I don't believe any such motion has been made in response to our petition, and so I alert the court to 132-1.4C4. Your Honor, it wasn't argued here. I'll throw it so the court understands, because we may get there. I don't know the circumstances of what other first responders came to the scene. Others have argued that that it would be in violation of HIPAA. And here, law enforcement, we provided you in a brief, law enforcement are not covered entities. Their receipt of protected health care information in the discharge of their duties does not then lead to them In addition, as I've said, this happened in the public view, I believe, in public street. And so that there wouldn't be any HIPAA attachment, or that right of privacy isn't involved. Your Honor, as I started saying, the eyes of the world are upon us. And whatever these videos show, it will show them upon release. And people can draw the conclusions that they want to draw from there. I am not aware of any instance in North Carolina where the videos have been released, whether it's in an officer-involved shooting, a police chase resulting in a crash and a death, and a claim of excessive force, where a judge has determined after their release that a juror or a defendant couldn't get a fair trial, or and thus prohibited the district attorney from proceeding with the charges. I've not heard of a case where a court decides that the usual arsenal of things that a court has at its disposal to deal with pretrial publicity are ineffective because of the release of the videos. I don't say this because past experience doesn't necessarily predict the future, but I believe in these cases, we've obtained release in all of them. There have been redactions, and there have been blurring and things like that. One judge ordered the blurring of a minor child's face at a shooting scene. We've blurred people sitting in a booking area as somebody is being processed and that sort of stuff. What I urge you to consider if you are thinking about those things is that hard cuts on video lead to speculation. Minimal blurring to protect people who are truly uninvolved makes sense, and it doesn't lead to the speculation. We have also had situations where a witness is giving an officer somebody's cell phone number or other contact information, and we've muted those so that somebody's personal information isn't being given out. We're respectful of that. I think, not knowing what's on the video, I think you can craft an order that addresses those things but gives the public as much information as possible so that they can have a better understanding of what transpired here in Pasquotank County. Do you have anything to add? With that, Your Honor, unless you have any questions. Those are
No,
mine.
sir. Thank you.
Thank you.
All right. With regard to this this petition, Mr.
Your Honor,
Womble.
and I'll be brief because I know Your Honor appreciates brevity. I just don't like being misquoted. And I stood up here and I did not say that there was not a public interest. I clearly said that public accountability was a public interest. I said that. In this case, it is outweighed by my responsibility to conduct the orderly administration of justice and also the potential rights of the accused or potential accused to a fair trial. It's outweighed. As counsel clearly stated, people will, his words, draw conclusions. That's what they're going to do. They're going to form and express opinions about what they've seen. And the video is the ultimate issue. This is not a tangential video. I don't know the ones that he's described. He's described the 30 or 20 odd times he's been around the state to obtain videos. I don't know what they show. I don't know that they go to the ultimate issue. I have no idea. In this case, they do. So, potential jurors in the First Judicial District will draw conclusions according to his words. They will form and express those opinions. It will hinder the orderly administration of justice, and it will hinder a fair trial. Counsel pointed out that no case has ever decided that you couldn't get a fair trial. Well, maybe they weren't articulate attorneys. Maybe they've held the trial somewhere where they don't have internet. I don't know. What I do know is that you cannot swing a skunk in front of a group of people and then ask them not to smell it. What I've asked is disclosure and release. I want Your Honor to give me an opportunity to complete this investigation, or the SBI to complete this investigation. Let me review it, make my decision, and then everybody can Monday morning quarterback me. Thank you, Judge.
Mr. Williams, you have anything you want to add?
Yes, Your Honor. Maybe there's something I'm missing here, and I miss a lot of times.
Mr. Williams, I don't think you missed that much.
I'm reading the statute 132-1.4A, and in subsection C, it names the people who are subject to disclosure, to whom it may be disclosed. They include a person whose image or voice is in the recording, a personal representative of that person, a personal representative of a minor or an adult under lawful guardianship, a personal representative of a deceased person whose image or voice is in the recording, or a personal representative of an adult person who is incapacitated. And then you go to the section F, dealing with release. And it says, notwithstanding the provisions of subsection G, a person authorized to receive disclosure. The media is not a person authorized to receive disclosure. A person authorized to receive disclosure, and then going on, may petition the Superior Court for an order releasing the recording to a person authorized to receive disclosure. The court shall determine if the person to whom release of the recording is requested is a person authorized to receive disclosure pursuant to subsection C. I submit to Your Honor that the press does not have standing and is not covered by this statute. At the end, if in fact you order release with a delay of 30 days, then they can get it when it's released then. And we would ask you to deny the request, and then I would renew all of my prior arguments on the county's petition as well.
All right, thank you, sir. Mr. High, I know that you were a party, your county was a part of this. Do you want to be heard with regard to this issue?
Just briefly, Your Honor, thank you very much, and good morning to you.
Good morning.
For the record, I'm Hackney High, and I'm here on behalf of the Perquimans County Sheriff's Office. And as Your Honor well knows, that is a county that's located adjacent to this county, just west of us. Elizabeth City is not within the jurisdiction of the Perquimans County Sheriff's Office, but shortly after the shooting, our office received a phone call requesting mutual aid assistance over here for crime scene preservation, for security, for crowd control, and the like. Due to certain budgetary constraints, we are a very small county, a very poor county. We don't have body cams, and none of the officers that came to assist local law enforcement were equipped with body cams, and we don't have any recordings of any of the events that we witnessed while we were here providing that mutual aid assistance. I just want to be clear for the record, there is nothing that we could release because we don't have cameras and there were no recordings made. And accordingly, I would just ask that the Sheriff's Department of Perquimans County be released from this proceeding and any further obligations that it may have.
You want to be heard with regard to that?
No objection, Your Honor.
Okay, I'll grant that relief.
Thank you,
You'll
Your
draw an
Honor.
order.
I appreciate it very much.
Yes,
Thank
sir.
you.
All right. Anything else?
Your Honor, just to address Mr. Williams' point, I want to make clear that the court is aware that the petitioners, my clients, the 20 media entities, have petitioned under 132-1.4 subsection G, which is the general release provisions. F is reserved for those entitled to disclosure and law enforcement. A major difference between F and G is those petitioning under F, which could be law enforcement or those entitled to disclosure, don't have to pay the $200 non-refundable fee. My clients paid the $200 non-refundable fee. Other than that, Your Honor, I would also say that with respect to speculation, the speculation and conclusions are going to be drawn whether or not they're released. We believe that release will will be, as I said, will quell the rumors or deal with rumors or vaccinate the rumors, because it will be facts that will be released. Thank you, Your Honor.
All right, yes, sir. Yes, sir.
Your Honor, I want to clarify one thing. Mr. Williams waived notice today, and I want to tell the court that he has, of course, not seen this petition today, and I want to apologize to him because I don't think we were sure if this was under F or G, and I do understand in G, so to the extent I caused any confusion to Mr. Williams, I apologize to him publicly, and this has just happened at a very quick, fast-paced. I think we're all learning a lot very quickly. As to the public records request, I've been inundated with public records requests, and I understand there'll be a time and place, and we do intend to address those, but I can't tell you how many I've received. So, again, sorry to Mr. Williams, and thank you, sir. Thank you.
All right, well, certainly we're not here today on public record requests, so we'll reserve that for another day. All right, anything else? Yes, ma'am.
Your Honor, Amanda Martin, also for the petitioners with Mr. Toddy. As Your Honor knows, we served last night and have filed a petition asking the court to address the scope of the curfew that is embedded in the Elizabeth City declaration of a state of emergency. And as Your Honor suggested, I have spoken this morning with the city attorney. We have communicated about this, and I asked him if he was comfortable with me to put this on the record since he is not here, and he responded, absolutely, he is comfortable with this, that it's the position of the city that working journalists will not be subject to the curfew, and that he's not sure yet whether that will be through an amendment to the order or whether it will be through a working understanding and application of the existing order, but that he was comfortable with putting it on the court record that working journalists will not be subject to the curfew that is part of the existing.
All right, well, that's absolutely
Declaration.
something, there's nothing before me, an order or anything before me, so I don't think I need to comment on any of that. You can continue to work on it, and if y'all can reach a resolution, that's fine. If not, and we need to take action on your motion, then we can do so.
I don't think that will be
Okay.
necessary.
All right.
Thank you, Your
Okay.
Honor.
Thank you. All right, so here's what I'm going to do. I would like to be at ease for a few minutes. I'm going to go back in chambers and put these matters down and render my decision, and I'll be back out to do that in about 15 or 20 minutes, okay? And we'll be at ease until that time.
Your Honor, I don't mean to be presumptuous, but I did prepare with the caption for our petition, the Form AOC order.
I'm happy to take that and look at
There
it. Yes,
there
sir.
are 4 basic links.
Thank you. All right, anything else before we, all right, we'll be at ease for about 15, 20 minutes.
Thank you, Your Honor.
Court be at ease about 15 to 20 minutes.
Grab my bag. Yes. Let's take it back and back so I can got all my stuff. to, the court is going to find that with regard to the media's request for release, that the media is not a party contemplated under 132-1.4G for release. But if they were, and it was appropriate to release to them, the court undertook the analysis under G with regard to release of recordings and finds that there is evidence that the release would advance a compelling public interest. There is evidence that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. The court finds that the petitioner is not a person requesting or seeking to obtain evidence to determine legal issues in a current or potential court proceeding. The court finds, number 4, that it would reveal information regarding a person that is of a highly sensitive and personal nature. Number 5, that the release may harm the reputation or jeopardize the safety of a person. Number 6, that the release would create a serious threat to the fair, impartial, and orderly administration of justice. And number 7, that confidentiality is necessary at this point to protect an active internal and criminal investigation or potential internal and criminal investigation. The court therefore finds that that good cause does not exist for granting the petition of the media petitioners, and therefore that petition is respectfully denied by the court. That is my ruling. I'm going to prepare a order to that effect, and that will be prepared sometime this week, and I'll get that out to you in a formal written format at that time. All right. With regard to 21 CVS 261, the petition of the Pasquotank Sheriff's Department to release records to Khalil Farabee, who is the adult son of the deceased Mr. Brown. The court's going to find as follows, that this matter is properly before the court on the petition to release. To the extent that notice was required, notice was given by with Mr. Williams agreeing to hear the matter on behalf of his clients, but reserving his objection for lack of notice. The court has jurisdiction in this matter pursuant to GS 132-1.4A and all subparts. After hearing the arguments for the petition and the response from the district attorney for this judicial district and counsel for the respondents of all interested parties, the court finds as follows. Number 1, that the Pasquotank County Sheriff's Department is a custodial law enforcement agency as that term is defined in the statute. Number 2, that Khalil Farabee is a personal representative under 132-1.4C4, and he's a proper person to whom the subject videos may be disclosed. The court considering the factors enumerated in subsection D of the statute. Number 4, that the court additionally considers the release of the video. In addition to disclosure, which the court finds is appropriate, I've also considered release under the statute using the same 8 criteria. And the court finds that, number 1, the release is a compelling public interest. Number 2, that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. Number 3, the person requesting release is seeking to obtain evidence to determine legal issues in a current or potential court proceeding. But number 4, the court finds that release would reveal information regarding a person that is of a highly sensitive personal nature. The court finds, number 5, that the release may harm the reputation or jeopardize the safety of a person by release. Number 6, that the release at this time would create a serious threat to the fair, impartial, and orderly administration of justice. Number 7, confidentiality is necessary to protect either an active internal or criminal investigation or a potential internal or criminal investigation. Based on those findings, pending completion of the investigation and any decision regarding the prosecution of the potential defendant, the court orders as follows. That the 5 body camera videos be disclosed to Khalil Farabee and his immediate family within 1 degree of kinship, and 1 attorney licensed to practice law in the state of North Carolina. That is disclosure. That the video be held from release for a period of no less than 30 days and no more than 45 days. and that will allow completion of any investigation being undertaken by the SBI and by the District Attorney's Office in this county. Number 3, that the state is to notify the court when such investigation is completed, and the court in its discretion will consider at that time further release of the video based on the factors as they exist at that time. The disclosure of the video shall occur within 10 days, and the Pasquotank County Sheriff's Department is ordered to blur or redact all facial and identifying features of the officers shown prior to disclosure. That means facial features, name tags, any identifying information of those officers prior to disclosure. The court in its final order in this matter will specify the timeframes within which the video may be disclosed. In viewing the video, there were certain portions of the video that were conversations between officers, between superiors. I'm going to evaluate those videos, determine which portions are appropriate for release and or for disclosure, I'm sorry, and then we'll provide that in my order so that the videos can be properly prepared to be disclosed to the family. All that to be accomplished within the next 10 days. All right, that's how I'm going to rule. Anyone have anything they want to add or ask with regard to clarification?
Your Honor, I believe there are 4 videos rather than 5.
I'm sorry, you're right, there are. Okay. There's 5 files, but there's 4 videos.
Okay, all right, thank you, Your Honor.
And so I apologize, you're correct. All right, anything else?
Your Honor, while sitting here, I received an order from Ms. Hale regarding our request also that went to Elizabeth City Police Department. With your determination that my clients aren't entitled to seek release under subsection G, are you dismissing that additional portion of our petition as well?
Well, I didn't hear that portion of the petition, I don't believe.
Well, I guess what I'm getting at is, if we don't have standing, we wouldn't have standing for that. And
That would be my analysis. But I mean, I don't want to prejudge it because I didn't hear that portion. So.
All right, Your Honor.
All right.
Would Your Honor consider certifying your order for immediate appeal?
I'll take that under advisement.
Thank you, Your Honor.
All right. Yes, sir.
Will you be preparing that order as well, Your Honor? I'm sorry.
Yes, sir,
okay.
I will.
All right, thank you. Major Wally, I'm sorry.
Your Honor, Major Wiley with the Sheriff's Office. I just wanted to clarify, it is 4 body cameras. 1 body camera does have 2 videos, so it was 5 body cameras and 1 in-car camera.
Okay.
As well.
All right.
Just so we're clear on
My
that.
apologies.
Okay.
Okay,
All right.
thank you, okay.
And I will specify that in my order, and I'll clarify that with you before I enter the order.
Thank you, Judge.
All right. Is there anything else that we need to take up today in this matter? All right, again, thank you all for being here. If everyone would remain seated at this time, we're going to adjourn court and give the officers the opportunity to do what they need to do before they can make sure that you folks all get out in an orderly fashion. All right? We'll be adjourned.
All rise. Oh, yes, oh, yes, oh, yes, this honorable court be in recess until next appointed time. God save the state and this honorable court. You may.
Remain until the sheriff lets you know otherwise. Yeah.
We let you,
Thank you.
until sheriff